It takes extraordinary guts to agree to be part of a test case. These individuals put themselves on the line for all of us, and we owe every success in this case to them. I'd like to single out just two of the plaintiffs at the moment, Nikki and Amy, as part of my explanation for how we got to where we are so fast. Nikki and Amy have two young children under the age of 4, and after being together for well over a decade, they married in Massachusetts in 2013. Amy is a student, and Nikki was in a very intense and personal battle against stage 4 ovarian cancer. Yet, despite everything else going on in their lives, they not only decided to be plaintiffs in our marriage lawsuit, but they also decided to fight for immediate recognition of their marriage. They knew that this decision meant that they were going to have to expose Nikki's personal medical history to the world, and that they were going to experience the most intense public scrutiny of their marriage and their family. They didn't want to be Indiana's first family, standing out here alone in recognition of their marriage. They wanted all families to enjoy the legal respect that they ultimately won. But they knew that if they fought for their family, they could accelerate relief for everyone in Indiana. They did this painful, difficult thing for their love for each other, for their daughters, and most of all, for us. And what a victory they won. The district court judge was moved by their story and entered an order requiring the state to respect their marriage as the case proceeded. And the panel of 3 judges that was assigned to hear motions last month then lifted the stay that they had imposed in order to preserve Nikki's and Amy's marriage, something that no other federal circuit court has done. And then they expedited the Seventh Circuit appellate proceedings beyond anything that any of us had ever seen before. The 3 judges who heard Nikki's and Amy's motion then chose to hold on to the case, which they did not need to do, in order to hear the merits. And so we owe Nikki and Amy the identity of our panel of judges as well, and as you may have heard, it was quite a good one. It is no exaggeration to say that if Nikki and Amy had not fought for emergency recognition of their marriage, this case would still be before the district court. The Wisconsin case would be up at the Seventh Circuit alone, and probably would linger there for several more months without a decision. So Nikki and Amy accelerated relief, not just for Indiana, but for Wisconsin as well. Thank you, Nikki and Amy.